Well, welcome. Thank you all for joining us for this wonderful day. Thank you so much, Natalie. Terrific job on the keynote presentation discussions, and really interesting time, and for all the work in putting today together. I'm Judy Germano. I'm a distinguished fellow in the Center for Cybersecurity. I'm also an adjunct professor at NYU School of Law and at Stern. And I am delighted to be here with a superstar panel. So you have their bios with all of their details, but we are going to talk today, about stuff. But before we do, I have to read the obligatory CLE credit instructions. This panel has been approved for 1 CLE credit in area of professional practice and 0.5 CLE credits for cybersecurity, privacy, and data protection. For attendees here in the room, you guys all signed in, you're cool. For anybody listening online, you will need to write down the magic code that I will give at a secret and appointed time during our presentation. I don't even know when that happens, but there's somebody in charge, and Mariana will tell me, and I will pay attention. So with all that, today we're talking about the global race to regulate AI. Back in 2023, AI became so hot after ChatGPT launched its thing a year ago that Collins Dictionary said, artificial intelligence or AI is the word of the year, 2023. What I'm starting to think is AI regulation is going to be the word of the year or words of the year for 2024. And that's what we're going to talk about. You had some start up with that. And with me today, starting from my left, we have Alex Southwell, who's a partner at Gibson Dunn. He co-chairs the Privacy, Cyber, and Data Protection Group and is on the AI Intelligence and White-Collar Cyber Practices at Gibson Dunn. He's a former criminal prosecutor. Next to Alex is Kate McKenzie, who's Senior Counsel at the Office of Privacy and Civil Liberties in the United States Department of Justice. Kate was a New York City prosecutor and also worked in DOJ National Security. And Nubia Shabaka, who is the Global Chief Privacy and Cyber Legal Officer at Adobe. Nubia has also worked in similar roles at AIG and Morgan Stanley. I've had the pleasure of knowing Nubia for all of those years and all those roles, and I'm delighted to share today's conversation with these distinguished experts and very cool people. So Randy Milch didn't want us to talk about the harms and scary stuff of cybersecurity because we're taking a new and different approach of not what everybody else is talking about. But if we're going to talk about cybersecurity regulation, we have to ask the big question, why? So in AI, the big question of why and what are the risks is, let's think about it, there's a ledger. People are terrified of all the harms and how AI can end the world. But people are also terrified that AI, they don't want to miss out. I mean, it's more than a FOMO, but a really serious losing opportunities and becoming a dinosaur in your business because you're not innovating appropriately. Understanding those risks and opportunities, or that balance sheet, is important to understand how we should think about AI regulation. So Nubia, let's start on the positive. What are the opportunities as we think about how AI regulation should be framed?
Okay, so I thought, what is my top 10 list? Ready for the countdown? Here we go. Number 1, it really improves the performance and the quality and the efficiency of summarization. So how many folks in the room would love your emails, all the new laws, your meeting, your minutes, summarized for you at the end of the day? It's like an extra virtual assistant. Show of hands? No one. Yes. Okay, so that's my number 1. And all that analysis, all that research, you should just get an accurate summary at the end of the day. Well, maybe accurate. You'd have to check it. But okay, number 2 on my improvement list is personalized and customized work products. So you develop training maybe in your role, or you have these contract templates, but you can always have customization. How good would it be if in your specific role, you didn't get the standard training that you fall asleep on every day? It was like customized to you in your role with great accuracy. Number 2. Number 3 on my list, chatbots. So in my role of privacy and security, my team gets asked the same questions, low-level, mundane questions over and over and over and over again. And so the concept that we could have this repository that we are already developing at Adobe and in use on the security front internally, where people could ask the question and generative AI gives them the answer in accordance with their access allowance to the correct question, is a key feature of how you and your company may want to use generative AI. Number 4, translations. Okay, so you did all this work, you created the correct documentation, and then you have to roll it out throughout, if you're an MNC, a multinational company, or not-for-profit, or institution, that then has to go throughout the world. Okay, how many of you use translations on your phone? Just think about that being rolled out throughout. Number 5, we've heard a lot about software code generation and having our engineers be able to be amplified by generative AI and helping to build code that then they, of course, could check. Number 6, obviously we've heard a lot about security and vulnerability detection and threats and automated patching, or at least predictive analytics with regard to what we might want to patch immediately, sev zeros and critical vulnerabilities and all that kind of stuff. Number 7, content generation. I work for Adobe. I would be remiss if I did not mention Adobe Firefly. Have you heard of it? Yes, that is generative AI that my company Adobe has built, where we all can be artists. This is amazing. I can't draw, can you? But now you can text, type anything you want, and it appears, magically appears. I actually did this, and my birthday was 2 days ago, and I created my birthday invitation by just saying what I wanted. It was magical. Go try it out. Number 8. So, generative AI has benefits. I think last year alone, 99.9% in terms of CSAM and child pornography, all of the data and the content and the videos and the images that we have within Adobe, we're able to significantly impact and find bad actors and find missing children. Great benefit. Number 9, so all of the large volumes of data analysis on the environmental and the health care, really to find cures. Who does not want an immediate cure for cancer and global warming? These are great benefits that can be extremely sped up with generative AI. Last is synthetic data. So we talk about these privacy-enhancing technologies in terms of how we use generative AI. Well, the generative AI could actually help produce synthetic data for training. That's my top 10 list, folks.
Well done, Nubia. Thank you. So now that we're so excited, we want to run full in, no regulation, let's just bring it on and go. Except, of course, we need the other side of the ledger. So Alex, what are the risks? Why can't we just run in and do all the 10 things and more that Nubia just
So I would say take the excitement and the energy and the great ideas that Nubia and her colleagues are doing are thinking about and effectuating and bringing to the market and bringing to people every day, and put it in the hands of criminals. Right? And that's really the first risk, and we can debate how much regulation can address that, but the most, I think, apparent risk relates to criminal actors using this amazing technology, right? And they use it to help advance their hacking tools, to create more advanced malware and other tools to automate and speed up the creation of hacking tools and to proliferate it in the world. They also can increasingly use the technology for sort of deep fake problems, right? So creating false visual or audio imagery that is very convincing, and that helps to, again, proliferate and more effectively commit crimes. There, of course, are lots of other aspects of it, training data poisoning, all that type of thing. One of the significant frauds that happens in today's era, which is perhaps not as sexy as some of them, is sort of more traditional business email compromise frauds, right? Where a firm or a company is tricked into sending a wire into the wrong place. Happens all the time. Significant things, significant impacts with the sort of romance scam field. All of that is so much more effectively done using AI, unfortunately. And I think there's limits, frankly, in where the regulation can come into play. But I'll transition now to talk about other risks where I think there is the possibility for more regulation. because of course there is also risk that doesn't come from the pure criminal actor, but comes from, perhaps good actors who are unwitting, unthinking, or have other motivations, right? So think about the ads that people see, right? So if you can use sort of AI and other advanced technologies related to what kind of ads are shown, and one of the prime examples the FTC uses about the concern about algorithms and indiscrimination is different people seeing different ads for, let's say, a credit card at different interest rates, depending on how the AI model has, mined their credit score. And so there is a lot that can be done to bring good offers and good information in front of people, but it's a theme we've heard about all day long, that if the training data is infected or has some bias in it, then that's what's going to come out of it. And that's the area I think there's more. There's lots to talk about on the sort of crime fighting side of it, and lots in the regulatory space and how we work with law enforcement. But those ways that well-meaning users are using it, I think is also a place where regulation can come into effect.
Well, I would just like to add, because you mentioned a risk of deepfakes. So, since I'm on the positive shine the light side of the coin, I'm just going to say, even without regulation, some industries and some companies like Adobe have thought of those problems, and that 4 years ago, because of that issue, which we knew was coming, we created something called Content Credentials in the Content Authenticity Initiative, which is like a food label for all of your videos and pictures to say who created it, all the editing that might have been done to it. Is this in fact, can you trust it? Is it a fake or is it real? This helps in political elections. This helps with people online. And so over 1,800 companies have signed up for this thing we created, Content Credentials, back in 2019 to counterbalance deepfakes. So we got to work together to make sure we have that correct seesaw balance in the middle.
And just a quick addition, one of the issues we think about in terms of how do you regulate a policy is, do you need an external regulator? Do you need a government entity? Or can you allow companies or the market to regulate? And there is a whole emerging sort of identitech space that is focused on in solving these very hard problems from the creators or from the companies themselves. And some may say it doesn't go far enough. Some may say you still need regulation. The Europeans take an approach. The Americans take an approach.
And we're going to dig into
yes.
all of that. But Kate, from the privacy and civil liberties concerns, understanding risks and opportunities really for in that context, what are some of the considerations, and is this concept of self-regulation sufficient, or are there reasons that we need to put a little more meat on the rules?
Yeah, I think that's a great question. And I will say my perspective is certainly like a little bit biased because I am a privacy lawyer, but I think that it is very hard to have a conversation about AI without talking about privacy. The AI use cases that do not implicate some form of personally identifiable information are very, very, very small. I heard one recently from Department of Energy. They were using AI to identify areas that were more likely to catch on fire for wildfires, right? Which is a fantastic use case and one of the very few use cases that I have nothing to say about because it doesn't have anything to do with privacy implications. So the privacy risks when you're looking at AI are they are present through the entire life cycle, right? Starting at the absolute very beginning of the training data. What personal information are you using to train your AI model, right? And these are the questions that we privacy practitioners have been asking about any time we're looking at new technology, which is where are you implicating an individual's privacy in the process of developing and using that technology? So these are the same questions that we've been asking. And I guess I will probably spoil my punchline now, which is I think where we're heading in terms of regulation is unfortunately likely going to be very similar to where we have found ourselves in terms of privacy legislation, with the great divide between the European approach and the very patchwork, sectoral, state-specific approach that we have here for privacy in the US.
And let's talk a little bit more about that. So if you can share with us, Kate, what's going on? I mean, we had our keynote presentations, but in terms of your involvement in Europe, and what's the state of play there?
Sure. So one of the roles, I wear many hats in my role, but one of the roles is I serve on the US delegation to the Council of Europe for the Convention on AI that Thomas is the chair of, that he was just speaking so eloquently about. And we are knee-deep in those negotiations. We have been over there in Strasbourg negotiating for well over a year with the finish line in sight. The aim of this treaty is to be the first legally binding global instrument governing artificial intelligence in the context of human rights, the rule of law, and democracy. So we have a very active delegation. We have been involved in every session that has happened, and we're really looking forward to seeing it come across the finish line and be completed this spring.
And in the U.S., Alex, we've seen lots of things popping up. What are some of the highlights?
So I think in the U.S., we have to think about it both in terms of legislative and executive, right? So executive order and legislative. And there's a lot of unique aspects about the American democracy and sort of how things come into play. I would say a significant player in the space is New York's Senator Schumer, who has been out front in trying to push forward comprehensive AI legislation. And his approach, I think he is a very shrewd political tactician, is to have a whole series of sort of listening tours, and had one yesterday, and he then came out with a comment about having the need for a clear duty of care to be legislatively imposed. And so, again, the idea being you have to have a duly elected body to pass legislation for certain aspects of control over technology, right? And so, of course, the big question is it possible? Will it be enacted? And we have a long history of trying to have comprehensive federal privacy legislation, which has repeatedly not gotten very far. Personally, I think there's a reasonable risk of some child-focused privacy legislation, but I would highly doubt that there will be, at any time soon, comprehensive privacy legislation or comprehensive AI legislation. Now, I don't underestimate Senator Schumer, and he may have some plan here, and it's interesting that the issues often bring about interest from both sides of the political aisle, and so I think there is at least some possibility. But in the absence of federal legislation, which is where we are today and probably where we will be for a while, there are two other actors, the states, which of course are many actors, and the executive. And so the states increasingly are going their own way, right? So after Senator Schumer talked, a representative in California said, that's great, we're going to go farther. And we have seen this in the privacy realm, where the California privacy law is sort of the first state comprehensive law, and that's become sort of the de facto norm. And we're going to see that, I think, in the AI space in particular as well. Now, whether that makes for good policy or good legislation, whether that provides clarity or inefficiency for companies as they grapple with those regulations, that's a slightly different question. I think it does introduce a real level of complexity that we have, particularly, which is a function of the American political system. Now, the last piece is the executive, right? So on the end of October, President Biden has also been very focused on, the Biden administration, on comprehensive approaches to AI issues. They recognize this is happening, and politically speaking, they don't want to be seen as, asleep at the switch or not on top of things. So in what they're able to do, and we heard about this from some of the panelists earlier, they can execute an executive order, but of course that has limitations. It doesn't have the power of legislation or law in the same way. It can't create specific obligations the way a law could, but it can incentivize. It can incentivize federal procurement decisions. It can incentivize the creation of standards. And so that's really what the executive order is about. It's about directing federal agencies to create standards. And that can be effective in some ways, but it takes time. And so I think from the US side of things, there's a lot of activity. It's somewhat diffuse and dispersed. It's going to lead to conflicts and a lack of comprehensiveness. But we've grappled with that before. We've grappled with that in the privacy space, and I think that's where we're going to wind up, but it won't be anytime soon.
And Nubia, you've been living in the privacy space for quite some time. Do you agree or disagree with Kate that we are going to wind up with a fractured patchwork quilt of laws and regulations?
Say it ain't so. I mean, but I must agree, right? I mean, unfortunately, I see history repeating itself. If you think about the timeline of last October, the White House puts out a Bill of Rights, and then January we have announcements with regard to the NIST.
Yeah.
NIST puts out the risk management framework, and obviously NIST, which is totally voluntary, really successful in the cybersecurity framework, maybe not so much. People started gathering the privacy framework a little bit later. So they have that. Schumer comes in April and says, oh boy, China is really on the move here. And so they come forward. And on the same day that we have the presidential executive order, we have the G7 putting forth their voluntary standards to say, world, we need to cooperate here. So the states are already up to 17 proposed state laws on AI. So I would be remiss to say we're not going to repeat ourselves when we're already up to 17 and it's been a year. That being said, I hope that we learn from privacy and do not have this continued conflicting measurement. Even if everyone feels the need to be in the space and put their stamp on it, I'm hoping that some of these guiding principles and collaboration frameworks and what we've learned from the kind of fractured framework in privacy, we do not repeat, even if everyone passes something. Hopefully it's a little bit more collaborative, but I'm not that hopeful.
Well, Kate, maybe you can cheer us up a little bit.
Oh, I don't know.
Are there at least some positions of harmonization among the different varied rules and regulations emerging, and what are they?
Yeah, so there are silver lining. There are some similarities, particularly when you're looking at the EU approach versus the US approach. One of the things that I think we can really focus on, we are both very confident in approaching this with a risk-based approach. The NIST risk management framework is what the US is hanging its hat on. The EU is taking a much more structured approach with their sort of bucket categories of high risk, medium risk, low risk. The benefit that the US approach has is it's much more flexible. You as an organization or an entity are able to look at your particular use case. You are able to apply the risk management framework and individual and sort of wet factor. They call it map, measure. What's the third one? Map, measure. Let's just go with maintain, but that's probably not it. But it is an M. So map and measure your risks, and then you prioritize them, and you determine which is the highest risk, which is the one that's your highest priority to mitigate, and then you work through it and you mitigate it, and it's based on your specific use case. The EU approach is also a risk-based approach, but again, it's much more rigid and doesn't allow for those individual flexibilities the way that we are doing that here. But I think that that's one thing that we can stand behind. And I've said this before, but I really do think that the US and the EU are heading in the same direction. We really are looking to get to a place where we can, without stifling innovation, provide the public with comfort that AI is being used in a responsible, ethical, and safe way. It's just a question of how we're going to get there, right? And it's the same philosophy that we've had when we've talked about data privacy governance for a very long time. And so I think we can take that mentality and apply it to this new technology as well.
Can I add a note of cynicism and then optimism, and maybe a question back to you both, is to say that we've learned from the past.
Well, we haven't fixed
think,
it.
Yes,
we're still doing that.
But
yeah.
I think one of the things that the political actors or legislators have learned is basically how to get themselves in the news and how to, they are inherently politically driven, which to me is the cynical note in the sense that you're going to have more aggressiveness and fights to get more legislation out there, not necessarily for the good sort of underlying, let's call them pure reasons. It's more about the politics of it. But the note of optimism, I think, is that increasingly industry is more engaged. And I feel like that is the
Yes.
case more so than previously. To me, that is a positive because I think the regulators and legislators understand that there's a limit, and some of them perhaps don't care that there's a limit on what they understand or know, but many of them are aware and you know, not quite that arrogant and would accept that and are interested in having industry involvement. And to me, that's the optimistic note that it may get ultimately to a better place. It sounds like you both are shaking your heads.
Yeah, I definitely agree with that. I mean, in July, way before the executive order ever came out, right, 15 companies, including Adobe, throughout some period of time, signed up for voluntary standards that kind of produced and turned into the executive order. And I think that this listening tour, not only from Schumer, but from many folks in DC and government, absolutely is happening. Listen, generative AI is not like a stroll in the park. It is complicated. So to think that you can just regulate generative AI with not tripping over and breaking something and having unintended consequences would be very silly. And so I do think that partnership, they do understand, is key. And so I am hopeful there.
Are there other examples of the industry engagement or advice as to how we can do more of that engagement and development to help drive appropriate regulation?
So from my perspective is I think the first step is saying appropriate regulation, talking about the US perspective, right? What is appropriate regulation for us, the US? We cannot be in, for lack of a better word, an arms race with the EU. We don't govern that way. Our regulatory approaches are very, very different. So we need to look at what has been successful here within the US, within our cultural norms and traditions of the way that we have historically approached emerging technologies, instead of feeling like we need to keep up with the European Joneses, and really look at, I personally think there's a lot to be learned from how we have not handled privacy quite so well, and say, this is an opportunity for us to do something different here. But also recognize historically we have always approached things with a very sectoral approach. Is there a way that we can, so what's really sort of part of what's happening with the AI Act is they are layering this level of regulation on top of their existing GDPR regulation and the infrastructure for oversight that they already have with their data protection authorities. That is not a structure that we have here in the US. But we do have is sectoral regulatory bodies, right? We have the SEC, we have the FTC. Are there ways that utilizing HIPAA and different laws like that we could layer artificial intelligence protection and regulation into our existing framework that would serve the US tradition, the US norms, but get to the same place eventually? That's sort of my thought about it.
So I 100% concur. We are a sectoral-based regime. And so we have had, please don't think this is new, whether it's healthcare, 40 years, or privacy and financial services for 20-something years. This is not new. This was not invented in 2018. So we've been doing this a very long time, but it is sectoral. So people mistake the fact that there's not some omnibus regime for no regime. And so there's a lot of mapping and explanations, but I do think it is not likely that we're going to get some new regulator in America that kind of regulates all of AI. And it shouldn't be, because it is very complicated and it is very sectorally specific, which you heard earlier panelists say. So I completely agree with my fellow panelists.
Thank you. And that is one of the questions. And Microsoft has pushed for a new agency on AI, saying we have expertise, and isn't that great? The counter to that is, wait, another agency? We already have 50 regulators who want to jump in, plus the states, plus all, internationally. On the other hand, IBM and Google have said, no, existing is right, and let's fold these in, just strengthen their capabilities. Or any thoughts, any benefits of having some unique focus given how important this is? Or are you all in agreement that we can just fold it in?
Well, I think you can have both. I think you need unique focus via collaboration and principles, but a unique regulator, I mean, that's the key difference. I don't think we need a new AI regulator in the US, but I do think it needs unique focus with skill sets from the various folks and coalition coming together to say, this is what we're going to abide by. And then coming up with a law is different also from enforcement. So you can have an omnibus law that a variety of folks come together to put together, but it's still enforced at your sectoral regulator. You can do both.
And one of the things from the EO is a massive hiring push at the federal government level to bring AI talent into the federal government. So there is an awareness that we need more of this specialized knowledge at the federal government level, and they're doing a massive talent search right now to bring folks in that have that kind of expertise. So whether that will take the shape of a brand new regulatory agency that then has a, different little sectoral offices within it, or that will be AI folks getting staffed up at the existing agencies, is to be determined. But the point is we need to have that knowledge within the government to be successful in this space.
And I'm actually hopeful that we will learn from the Europeans and think a little bit more broadly about the issues, and recognizing we have the sectoral approach historically, which has good historical reasons, but that doesn't mean we have to be wedded to that and have an AI rules in this place, that place. You could have a much broader principles approach, Bill of Rights concept, if one thinks a little bit more broadly in the United States, and that could be very effective. But I think it's then different to the enforcement or the regulator, which is sort of a body or an office. And we've seen in California how they've now created a new sort of regulator out of whole cloth, and I think it remains to be seen sort of how that plays out and what the effect of that is going to be. But again, it comes back to our unique sort of federalist experiment of having the states and the federal government. We're going to continue to see some states do it. So it wouldn't actually surprise me that there would be some state regulators in this space, which at a certain level is just either to be expected. I think there's a sufficient risk of inefficiency and challenges that might come from it, but we have to recognize that that's how things work here.
The risk of asking if we can put toothpaste back in the tube. Is this really the right time to regulate? Or is this a situation where everyone's doing it, so let's all jump on too? Is it premature? Do we really understand enough of the risks and the opportunities to get a sensible regulation? Or is this just going to be a hodgepodge because it's a sexy hot topic of the day and everybody wants a speaking point on it?
So I heard a great story last week, and if anyone was at the IAPP AI Global Governance Conference, I apologize, but I am definitely stealing Trevor Hughes' speech. This is a really great example, I think. So
he got it from ChatGPT. It's all.
Oh yeah, okay.
I'm just
Okay,
kidding, Trevor.
Fine.
No, but yes. Okay.
So he said that when the car was invented, it had no brakes, and the car rolled into walls and it would crash, and there was no way to stop it. And I am not much of a historian, so I had never heard this before, but he goes on to tell the story of the inventor's wife who actually comes up with the new design for the brake pad. And the brake pad is essentially the thing that saves what would otherwise be a disastrous piece of technology. And the regulation and the requirement that cars have brake pads saved it, because the public then had trust that if I get into this vehicle, it's not going to kill me. So the reason that I think regulation is critical now is because we are at that tipping point where we either have the public's trust in our use of this technology or we don't. And they are scared of it and they think it's going to harm them, their communities, and their families. If we take this opportunity to be thoughtful and intentional about how we regulate, we can make it the car of the future with really good brake pads. That's my thoughts. And that's Trevor Hughes' story, so.
That's a great one. I mean,
Well
I
done.
think it's the reality is, maybe I hope it can be both, right? We have to act now because it's just so prevalent and there's not a way to not act and there's not a way to wait, and because lots of others are acting. But at the same time, hopefully, we can pause and not rush headlong without thoughtful consideration. And the Europeans, I think, generally are pretty thoughtful about it. Some might say thoughtful to the point of it taking a very long time to have their, colloquies and discussions and in the very European way. And the Americans, of course, on the other end of the spectrum, like rush in and they sort of, create something because of their hope to enact law. So my hope is we find someplace in the middle where there is thoughtful consideration that ultimately leads to some regulatory type body.
And because it's moving so fast, it's just really key that we have this flexible, adaptable risk-based framework that will grow with us, right? That seatbelt needs to be able to adjust as you grow older and taller and slimmer and thicker, and otherwise it will just break and we will all hurt ourselves and fly through the windshield. So keeping with that analogy, I think that if we have to regulate now, which I think we do, I think the toothpaste cannot go back in the container. I just think it's really critical that we have that principles-based approach, which is outcome-based, preventing those harms, and not prescriptively telling people what you must do exactly, because the technology is going to always move quicker than the actual law, and we don't want it stale next year when you hear this speech next year and you're like, wait, you told me this, and it's already in the rearview mirror.
And if we're going to talk about regulation, we have to talk about stew or soup, which means carrots and sticks. I guess there's no sticks in soup. That was a terrible analogy. I take it back. Let's talk about carrots for regulation. We need incentives, we need safe harbors, not just enforcement, which is the stick, which we'll get to next. What are some of the carrots we can consider with regulation, or that is existing in current regulation and proposals?
So I mean, from our perspective, Department of Justice, one of the biggest carrots that we use is federal funding, right? We have the ability to offer grants and funding to law enforcement agencies, and we can put limited conditions on their receipt of that. One of the things that's been very successful for us with regard to the use of facial recognition technology has been that any law enforcement agency that is receiving funding from the Department of Justice has to have a policy in place about how they're going to use that facial recognition technology that accounts for privacy, civil rights, and civil liberties implications. So, money is probably the best carrot you can get.
And I promise I won't put sticks in my stew.
I would also say that many private sector companies are vendors to the government.
Yep.
And so it is a very big carrot to keep that procurement dollars, but also a big stick that, listen, whether that's in the Europe or in the US, if you're going to contract, that you must follow these prescriptive rules. And so I also think it is a precursor to what often gets carried forward into the private sector. And then I also think laws generally, there are class action plaintiffs, and there's a reasonability standard, and I think all of those things feed into, once they start getting codified in various laws, no matter where they sit, it becomes sort of an expectation of what is appropriate and reasonable best practice, and so it all kind of flows together.
Well, and I would just add, there's also the market dynamic, which is you can, create an enterprise, a company, a product that promotes the compliance or safety in respect of sort of AI discrimination or whatever the right issue is, right? We've seen this in privacy compliant solutions becoming a market differentiator. The flip side, of course, is that if you have risk in that side, it can be reputational risk, et cetera. So it's both sides of the coin, but I do think can be a market incentive or a market imperative to be seen as doing the right thing. And that leads to good behavior, so to speak, or it leads to that.
As an example.
Yes, what perhaps?
Perhaps I could mention. So for example, Adobe, when we released our generative AI, we said we're going to stand behind what we put out. And so we offer an indemnification from a copyright perspective, which people were not doing, because we have all of our content. And we said we're going to stand behind it. We are designed to be commercially safe. Other businesses can use our products, and we will make you whole if anything happens. That is a good, number one, we believe in our product. Trust, our customers should be able to trust us, but there's a market reaction to that because not all generative AI is created equally, and many, many, many other companies are not offering indemnifications, for example. It's a good point about the market.
And then on the enforcement side, Alex, what should we expect to see, and from whom?
So I think this is another important aspect to the discussion because we talk about regulation, we talk about legislation, the executive body, but the other way the executive acts is through enforcement. And we have a phenomenon, particularly in the United States, where you have regulation by enforcement. You have the enforcers settling cases and then pointing to those settlements and saying, those are the new rules. So the FTC does this all the time. The attorneys general do this all the time. They come up with a settlement on a particular set of facts, and they essentially point to that and say, these are the new rules. Now, there hasn't been a rules process, there hasn't been a rulemaking, there hasn't been a legislative discussion or a vote by duly elected legislators who could be voted out. But yet that is part of the phenomenon that happens. And the regulators and the enforcers would say that's an important part of their duty, and that's what they do. And so the bodies that we see particularly active is, of course, the Federal Trade Commission. They had a significant settlement against Everalbum, and in the facial recognition space, the way they couch their settlements typically relates to consent or lack of consent. It's much less they're investigating sort of the use of AI, but the resolutions are really just they're more traditional UDAP sort of, unfair trade practices, resolutions focused on failures of consent and things like that. But we're going to see the FTC continue to be very active in the space. They had settlements in the space with Ring and Alexa. See, the California Attorney General had a sort of non-AI settlement with Sephora, but it had an AI angle to it. We see other regulators now, the CFPB, HUD, who are active in the space. And unfortunately, again, in the United States, we have this, I don't know whether it's some inherent competitiveness, but we've got the competitiveness amongst the regulators. They all want to, it's almost like an arms race of regulators wanting to enforce actions. So we've seen a number of those entities, but of course, there are also the international entities, right? The Italian DPA has been active, the French CNIL, the UK ICO, and others. They're all very active in the space. And I'll note a couple interesting angles to that. There is both the resolution, the fine, the public reputational hit that comes from an investigation and a settlement. But interestingly, I think notably, there's the requirement of basically purging the data, purging the sort of AI-related either training data or results or modifying the algorithms, right? The regulators have gotten much more focus on sort of descending into the business, so to speak, in a way that they haven't in the past. Some would say that's a good thing. Some might say that's not a good thing. I think it depends perhaps on where one sits in that regard. And as long as the regulators are sort of really thoughtful and careful about it, it's a reality I think we have to grapple with.
It's time for me to read the secret code, which will no longer be secret.
La, la.
All right, again, if you're here in the audience, just make sure you signed in and signed out in person. But for our fans by the TV, the code is CCS, like Center for Cybersecurity, 3290. That's CCS 3290. So virtual attendees will not be able to receive CLE credit without noting that on your attorney affirmation form after the event. CCS 3290. Thank you for joining, playing along. So now we have the enforcement, we have the incentives. Nubia, you alluded earlier to let's talk about self-regulation or certification and the Content Authenticity Initiative. Is there more that can be done to address this by self-regulation, and how?
Yeah, I think that companies certainly who are creating generative AI don't want to wait however long the regulation process takes. And so I definitely think being open and transparent and putting out there for our customer base and regulators to judge until that all comes into effect. I don't even know how long it would take for some certification to be created to say, oh yeah, you are compliant with this AI certification. I think that that is likely to come, say, quicker than the various laws. But in the interim, I think plenty of industry are coming and working together to really try to build the foundation in an appropriate manner to make sure that customers and society at large feels comfortable using the products that we are attempting to create. And so even before regulation and self-certification is really just that transparency to society at large and trust. So for example, within Adobe, when I came out to Adobe over a year ago, but I report to, for example, the Chief Trust Officer. And he is also the General Counsel, and myself as the Chief Privacy Officer and the Chief Cybersecurity Legal Officer, and also our public policy person that does AI ethics, and also our Chief Security Officer from a technical perspective. We all, and others, our intellectual property person, we all sit in this Chief Trust Office. And so this concept of putting out information, publicly putting it on our website, speaking to customers and consumers in roadshows, et cetera, we have something called a Common Controls Framework that we publish about all of the various initiatives from a security and privacy perspective and how it complies with all the various laws around the world. It is kind of a self-certification until someone else comes up with it. It's our own proprietary tool that we've created. And so we're doing all that we can in this space to show how we are a trustworthy company and distinct from others, not all others, but this is our brand and our model. And so we are moving full speed ahead in that regard.
And Alex, I know you advise a lot of different companies who have to grapple with global rules and rulemaking and considerations of what the rules will be tomorrow. So what guidance can you offer for companies addressing this evolving area of regulation on AI?
So I think there's actually a lot of similarities to how we think about cybersecurity, because the risks for AI and cybersecurity are, of course, intertwined and similar, although also slightly different, but they're all, cross-sectoral or cross-organization, right? You cannot deal with the issues in a silo, right? So you cannot have the engineers figuring out an AI solution or the marketers doing an AI solution. You have to have that cross-pollination. And that is something that many companies struggle with. I think many companies are aware of it and they work towards it, but it continues to be the case for lots of institutional reasons. And so what I often talk with clients about is very similar to the cybersecurity realm, is that importance of cross-functional teams, of talking across the silos, so that you can be most effective in how you're thinking about the risks, because the risks are holistic. The risks are from different quarters and they come out in different ways. When you have the overlay of the different regulations, that of course becomes much more challenging, right? And so one of the things we do, there are sophisticated in-house sort of legal advisors and outside counsel who help to think through how do we think about the different laws and what's sort of the lowest common denominator, what do you have to work towards? Because the frank reality is in the privacy realm, the cyber realm, and sort of AI, even if you don't know what the regulations are going to be, it's probably likely a company is not going to be able to comply 100% with all of them. It's just generally not possible. And so one can think about that and help to think about how I operationalize the type of work that a company is doing with that overlay of compliance and the rules that are in place. Do I have operations in this particular jurisdiction? Does that jurisdiction apply to me or does it not apply to me? Or am I going to move into that jurisdiction? So I have to anticipate and think about how it's going to apply. And I think those parts are often the hardest. It's the thinking through what's coming. And the key, I think, again, is to this sort of cross-pollination idea, is to have the folks who are thinking strategically. What am I going to do in this year or 2 years from now or whatever, the roadmaps, because companies like to all they think about their 5-year plan, and it's making sure that they call up Nubia and say, this is my 5-year plan. How does that sit with what's coming in terms of regulation? And I think the sophisticated companies are pretty good at that. The challenge, I think also, or a challenge, is the smaller companies, or the more mid-sized companies, companies that are really growing and emerging, and they don't have the resources and the capabilities to have those kinds of in-house teams who are going to help look ahead and do it. And so that remains a challenge, is thinking about how you handle sometimes conflicting regulatory issues, and how you think about making best products and putting out making good and effective business decisions.
And Kate, for companies that are trying to grapple with this AI regulation and challenges, what opportunities might there be to interact with the government on these issues? And what's the best way to consider that, or for them to think about that?
So the federal government at large has been doing a lot of engagement with stakeholders about AI, not only the tech side, but also the civil society folks as well, and the public. I'm working on an interagency report right now, and we just put out a call for feedback regarding the use of advanced technologies in law enforcement. So and that's coming from public sector, also coming from the industry side, as well as coming from the folks that would be impacted by the use of this technology, right? So there are opportunities like that. I do think that the administration has been working very hard, and particularly NIST has worked very hard at making their framework accessible to the public and to organizations that want to use it. There is a whole toolkit of documents, including a roadmap, a crosswalk, a checklist. I mean, it's everything under the sun in terms of ways for you to operationalize this risk management approach in your own organization. So that's where I would turn to if you're looking for guidance on how to effectuate this approach in your organization. If you're looking for opportunities to engage, look for them. They're out there. We are asking for public feedback and public input in a number of different realms. For the Council of Europe delegation, we've had a number of stakeholder engagement sessions to talk about what our negotiating position was going to look like and how the US was approaching those negotiations. So there's lots of opportunities if that's where you're looking to be heard, yeah.
And we're going to ask for audience questions in just a moment. I have one more question, but then if you're online, you can submit questions, or in person. In terms of the different regulations that we're seeing, both in Europe, in the US, those now and those on the soon horizon, what do you think would be, for each of you, the key priority issues for those regulations? What either risks or opportunities should they be trying to address, or concerns?
I'll start. I mean, I think there are some things that are in the EO right now. I mean, sort of they don't have the force of law yet, but a requirement of testing and checking. Those are all good business. There's good business reason for that, and one should hope and expect that companies are going to do that kind of work. But I think there is something to be said for law or regulation that sort of makes that a little clearer, because that helps for the companies that aren't as sophisticated or maybe not as thoughtful about it, right? So an awareness of where you get your training data from, and ensuring that you really have the right to use that training data in the way that you're using it. Some requirement to test the training data and to understand if there are already problems or biases in that, and then some testing of the output of the AI. Some requirements along those lines, which again are fairly rudimentary, and I think what most companies would agree with as best practices. Some sort of encapsulation of those best practices, I think, could be something that a lot of people could agree on.
Yeah. I would also say, just as a very high-level principle, in terms of, because I agree with everything that Scott just said, my high-level concern is that we not regulate the technology itself, but rather focus on the uses and the effect of the technology, right? I think particularly when you're dealing with a new technology, the knee-jerk reaction can be like, well, let's just ban this particular technology then. Let's be a little bit more thoughtful about it. Let's look at the particular use cases and look at the outcome of those use cases and focus our regulation there rather than on the technology itself.
Yeah.
So 100% agree, outcome-based. We should really be thinking about the use cases and high-risk use cases and not stifling innovation. and to really have a shift in how we think about privacy in relation to AI, not so much minimizing personal information, but maybe somewhat controversial coming from a privacy person. But is there some new shift in balance as between individual rights and societal rights and balancing those risk and rewards? And can you comply with all of those specific privacy requirements in this AI context? Does it neatly fit, or do we need to tweak some of those rules in the AI context? I think all of that should really kind of be reconsidered.
Nubia, Kate, Alex, terrific points. Thank you, thank you. I see there's a question there. Okay.
Thomas, actually it's not a question, it's a comment or two. One, I think it is absolutely crucial what has been said, that for every country you need to find out which is the approach that works in your country, given the legal, the institutional and the cultural tradition. And the thing is that, and the other thing is evidence-based policymaking is something that is, you hear in every conference, you hear every day, but it makes a lot of sense, because the question is, there's normally enough scientific research around which measure has contributed to what extent to an outcome. And with AI and so on, we can do this analysis much better. And I give you an example also from the road system. When you take a mountain route from Italy to Switzerland, on the Italian side, it goes up to 2,500 meters. You have guardrails all along the route until the very top where you have the border. And then you cross the border, and in Switzerland, you have nothing. You have a 100-year-old stone of that size every 15 meters. And the road, if you fall off the road, you fall off 1,000 meters, you're dead. And they think, like, oh shit, how dangerous is it to drive on the Swiss side? Where do you have more people dying in cars, in Italy or in Switzerland? In Italy. And the funny thing is, in Switzerland, you have a much stricter control of the functioning of the car and much stricter tests on the ability of people to drive. But you don't have a speed sign at every turn. In the mountains, it's just 80, and you need to know yourself how fast you can take the next turn unless you fall. And this is it. So two basic rules where you put a lot of stress, but then you get rid of lots of unnecessary regulation if you take these 2 points seriously, and you achieve a better result than if you take it from the wrong end. That's just one example. Thank you.
Can I pose a response to that, though? Because in today's sort of era of how you regulate, right, the European Union wants to impose their rules with 15 meters and little stone blocks on every company in every place in the world, including American companies. And so there are important cultural and legal norms of each society, but one of the functions of the technology age is that political borders have sort of disappeared at some level. And so there has to be some grappling with the reality that the regulation is going to have a worldwide effect. Some may say the GDPR was in fact intended for American tech companies. And so I'm not to diminish your point at all, but to expand upon it and think about it in the digital today.
If I can just quickly, and this is why it is so important that we have this global debate.
Yes.
We are a very small country, 8 million people, now 9, we're growing, but we're still not the biggest one. But we do sometimes think there are ways to solve problems because we've been living with risks in the mountains and waters for quite a long time, and we learn to protect ourselves through behaving reasonably and not have a law for everything, may actually be more efficient than what our German or French neighbors do, although it's well intended and we share the same objectives. And sometimes the US or the UK is closer to our approach in letting things happen, trying to understand what the problem is and not try to guess what the problem could be in the future, like more ex post than ex ante if you don't really know. Yeah. And so if we together can have a global discussion on sharing the same goals, and maybe we can also have an influence in the EU if we are not just doing nothing and wait until they think they have to be the first ones to tell us how, if we dare to go with them in time and discuss how we could do it, then I think we may actually have better solutions than if you just let one culture go ahead. So yes, I'm with you. Thank you.
We can hope.
And there'll be a lot of driving cars across the border. We need to figure out what the guardrails are and the correct things. Thank you so much. Yes, sir.
My name is Jonathan Meyer. I work with the American Bar Association. I'm co-chair of national security and also international committee. So I have a question. First, it's for you and Nubia, and that is you made a statement before how AI can help track child pornographers and perhaps I would also assume human traffickers. I'd like you to elaborate on the first stage of the question. I picked it up before, how that can be of assistance. And second, I was wondering if the conflict in privacy laws that may exist, for instance, we had a safe harbor provision in the United States years ago that was abrogated, and also the GDPR, how there may be an overlap with that and AI. For instance, the protection of privacy laws and the conflict in the global privacy laws. I'm wondering if we can use that as a mechanism also to perhaps regulate or have an effect on the AI. So please, Nubia, if you can.
Yeah, so on our public website on adobe.com, we have a trust and safety tab, and we post a bunch of statistics on how we help law enforcement when it comes to law enforcement requests, including CSAM, and those are just the latest statistics. We post them every year, and so we use our deep catalog and our leading video and photography related stock imaging and aging when children are missing for a long time to show how they would look later. We just are a leader in this space, and so we work with law enforcement to catch criminals in compliance with the law. It's not my actual department, so I don't want you to think, wow, privacy does everything. No, but I thought it was helpful for me to just bring up another example of how we work for the greater good in using AI. But there's more information on our public website.
Well, and on the privacy issues, right? So to the points earlier, so much of AI is related to privacy because it's all about the use of private data. That's where the real benefit comes up, other than the fire, finding the fire hotspots. That's an interesting one. And so for that reason, you have the overlay of GDPR or other privacy regulations that are just an important element of how you think about AI regulation, because they can't really be separate. They have to be connected. Now, AI regulation may have other aspects. There are other issues, risks, and opportunities that you can see in that legislation or regulation, but it's all privacy grounded, I think, in a large respect.
Well, and isn't one of the concerns in terms of what are the inputs in the models and how are those shared, and might that have certain privacy implications? And I think, Kate, that's something that you've addressed or can speak to.
Yeah, absolutely, right. So I think the short answer is the GDPR doesn't solve it all, because otherwise we wouldn't be having the conversation about the AI Act, right? So AI is special. It is more than just privacy. I have heard some people get very angry and say like, oh, just because these privacy lawyers think they can come in and they know the answer to AI is different. It's like, okay, yes, but privacy is a big piece, right? Like, because not only is it the training data, it's also the information you're feeding into it, right? And if I am feeding information into it that's my identifying information, what is the model going to do with that information? Is it essentially eating it and taking that?
Sorry, exfiltration of that information, that's another problem. The exfiltration.
Yeah.
Right. So there are a lot of different points at which humans are interacting with this model with their individual data. So it's so layered, and I think that's part of the reason that we can see that there's more beyond just the GDPR that's going to be necessary here.
Yeah, and so when you think about governance in those cross-functional groups, right? So within Adobe, I sit on a bunch of AI-related forums. So internally, we have our own productivity forums and our IT group, and we have our innovation group, and we have security, and we have privacy, and obviously there's a huge intellectual property component on who owns generative AI and changing those laws, and it is truly, truly cross-functional. And so if you are at a company that does not have a dedicated AI kind of collaboration group, maybe it's fallen to the privacy attorneys because a lot of it seems really similar, from impact assessments to transparencies. It seems really similar, but it is truly cross-disciplinary in those 4 or 5 or 6 different discrimination and all these topics that I'm mentioning. And then also you have to add in, of course, if it's externally facing and you're selling a product or service, then you have all the product people, you got to communicate about it. Do you have your corporate communications people involved? It is like really, really cross-functional. And so I don't want to personally own AI because privacy is one component, even if it's a big component, it is like 10 different functions.
Yeah.
Boris?
Hi, everyone. I'm Boris Sagalis. I'm a privacy lawyer at Goodwin. I'm going to start by trolling Trevor Hughes for a second.
Oh no.
So Kate, when you said that, I looked it up on ChatGPT, and it says, yes, early cars did have brakes. The first automobiles were equipped with rudimentary braking systems, often using external contraption, whatever that was invented 200 years earlier for horses and carriages, right? Because carriages needed brakes. My point being, like, think of the old brakes as like the FCRA, right? The point that you were making, that the tools to address exist, and some of the risks that we think about are imaginary, like Trevor Hughes telling the story about new brakes. But here's my question. You know, for the past 6 years, I've worked only really with emerging companies because I've been co-lead at Goodwin. And these are the companies that are on the cutting edge. They're the ones disrupting industries. They're inventing AI applications. And you know, like you talked about this, using AI to identify potential fire zones. Like if we asked anyone here to think of that, that's an incredible idea. So all of this comes out. So, and again, going back to IAPP, if you look at IAPP, emerging companies are not represented there because, you know, emerging companies have founders, they don't have lawyers, they're aggressive, they're trying to push things. So when we talk about like the policies that you talk about, kind of the big picture things, the conventions, all of that, that goes, you know, emerging companies are not there, right? So all of this technology is often developed in kind of an environment that's very, has a high appetite for risk. So that's where this AI invented. So, but it's not here. I mean, Han is here, but it's not plugged into the policy making and all of that. So you talked about legislation, all of that. How do we think about, like, that's where this technology developed? Like, if there are regulations, or if there are no regulations but policies, how do they really affect the real life development of AI by these emerging companies? What do you think would be? How do you regulate it through like the ideas and policies where it's really happening on the ground?
So yeah, I mean, I think it would happen when they went to market. Would be my gut reaction there, right? If they came to market and they were not able to prove that they were in compliance with the regulation, then they would be in trouble, right? But again, I'm a public sector person, so
Yeah, I mean, look, I would say we've seen this, you know, in other situations, and the sort of the classic articulation of it is ask permission or ask forgiveness, right? So the founders and those who are just, you know, hard charging, they're going to try to figure it out, get market share, make a product people care about, and try to ask for forgiveness later, versus ask for permission beforehand, because that's going to take forever. And you think about rideshare companies. If they had asked for permission to create rideshare, they would have gone through the bureaucracy of all the local jurisdictions. It would have taken 5 years. They would have not been able to launch in the way that they launched. And people can, you know, debate whether that was good or bad, but that's sort of how it went. And I think particularly in the AI space, to illustrate it maybe, is what data are you using, right? So if you think about an AI company, there are ways to get data, right? You could scrape the data, you could steal the data, you could create the data yourself, you could pay for the data, you could ensure that you have good consent for the data. There's lots of options. Some are more expensive, some take more time. And I think for the thoughtful founders and leaders of growth companies are thinking ahead. I mean, they're both thinking about how am I going to make my numbers this quarter or next quarter, but they're also thinking about what's my exit strategy and how am I going to go to market. And particularly in this space, you have to be thoughtful about, you know, what if you can't exit if you have stolen data that you're built on, right? That's not fixable. That's not a place you can sort of get forgiveness for. And so I think we're seeing more and more as technology companies sort of emerge and they take different tacks. They're trying to be disruptive, but you've got to be disruptive within the bounds of reality. And hopefully they have good advisors. They talk to Boris. They try to get some guidance on how to do it the right way, which is not often maybe the quickest way or the least expensive way, but it does result in outcomes that are more achievable down the road.
Professor Milch.
So first of all, thank you all very much for doing this. I think I thought I was loud enough. Following on to Boris's question, this is sort of a factual follow-on. I'm just sort of interested. When you're talking about public engagement in the process and the engagement that might be occurring internationally as well, domestically and internationally, is there any voice of the, as Alex called them, the growth company, or as Boris called them, the venture company? Because one way of looking at this, not that it's my way of looking at this, but one way of looking at this is you have very large companies who are essentially creating a set of regulations that's designed to limit competition, right? Because they're the only people who can afford to meet the regulatory burden. And you have public interest entities. Some people would call them officious intermeddlers, but you have public who are paid largely by companies to go off and because they're greenwashing their guilt. And they're out there talking with the regulators to come up with the regulation. I don't hear Boris as a factual matter. Are there any of Boris's companies in the mix discussing their needs or their limits, or is this really sort of once again the oligopoly of the large companies and the do-gooders helping government create a walled garden for large companies to act in? Some could ask that question.
So it's a very fact-specific question, but we do have the Small Business Administration that is involved, and presumably, I mean, I don't work for them. I don't know who they exactly represent, but that's the first thing that comes to mind when you say that is I'm imagining a group of people that's essentially like an advocacy group that represents these small startup companies. And I don't know if they're that well organized, frankly, possibly not. But in theory, those would be the folks that would be representing their interests.
Yeah. I mean, the White House and Senator Schumer have hosted these sort of listening meetings, town halls. I haven't looked at the list of who was invited to the White House beyond like Adobe and those companies. My guess is that they were thoughtful about it, and they probably had one seat that sort of represented, some smaller business, and query whether that's going to be sufficient or not. But I think it's a really interesting question. Ultimately, though, a lot of those smaller companies, again, where many get their value is in being disruptive and doing something different, and so they don't necessarily want to be in that same room. They would sort of fashion themselves as smart thinkers about a problem and coming up with a different way of thinking about it. And I think there's something to be said for that. And maybe even if they're not in the room, they can still find a path to bringing something successful to market or bringing something of value to people. But I think it's a really good question. I would look at who was invited to the White House meetings. And that'd answer the factual question. I don't know what the answer is though.
Yeah, and I'll jump in and say that we don't have our Defense Department colleague here anymore, but there are agencies that have technical departments that are bringing in a lot of startups, especially for tech-fed use case shows.
Yeah.
And so when you have those kinds of conversations, I think there's in my experience, and the one that I always participated in, there were always appropriate kind of regulatory and privacy and ethical issue conversations around these companies that are trying to pitch new technologies, because I think the governments are always looking for new ideas that are out there floating in the market ecosystem.
And one of the ways the federal procurement power brings that to bear is they're looking for that. They're also looking for historically disadvantaged companies or veteran status companies or other smaller companies. They're looking to provide opportunities for those, and so that's another place where the procurement authority and sort of harkening back to the executive order can actually bring some of those smaller players into the fold.
They actually did something that just jogged my memory, but the administration did something very interesting in the last year or two, not specifically with regard to AI, but in the privacy enhancing technology realm. And they partnered with the UK to do a prize challenge. And it was for small startup companies that could solve the problem of creating a privacy-enhancing technology federated learning model that solved for X, right? Whatever their problem was, and they rewarded them with $100,000 or something like that. And it was a 6-month prize challenge, and so they were getting these small companies to be using the technology and trying to solve these problems that we didn't have a solution for, and they got a lot of recognition and some funding and all of that. So given the sort of feel of the administration at this point, I would not be surprised if they tried to do something similar with regard to AI. It would be a really good fit.
But great points about making sure the right voices are at the table and different size and types of voices at the table. And then in terms of the conversation at the table, any guidance, last thoughts on how we can better harmonize, get more similarity in the rules, less patchwork in the rules, both domestically and internationally? Just for a zinger at the end, it's probably
that's a hard one.
unanswerable.
I would say that you want to engage with the technology, and one of the things I think that is a challenge is, and you see this in companies all the time, where the marketing folks will come and some vendor comes, and frankly we see this in the law enforcement sphere, right? Some vendor comes to law enforcement and says, we've got this great tech product, or they come to the marketing department and say, we're going to make your ads on steroids, and it's going to be incredible, and people are like, awesome, you're going to make my quarter, you're going to make my job, I don't really need to know the details of how this works, let's do it. And it's the conversation about how it works and actually having the conversation about that can be really important. It's hard because the technology is really hard and people don't make the space for it. Nobody has the time for it. But if you can have some of that conversation about the technology and understand it, not necessarily understand at the granular level, but sort of understand how it's going to work and how it's going to hit sort of hot button issues, to me, and the same applies to the regulators and the legislators, like if you can get them to sort of understand it and actually pause and have a conversation about the technology, you're going to get a better outcome, whether that's in your vendor agreement or your business plan or in your regulation or legislation. You're going to get a better outcome. The question, I think, is do people take the time to do it? So my hope would be that happens.
I would say all of that. And then I would say, let's not overregulate until we know more. I would much rather get halfway to the finish line while the technology continues to evolve and let us come back to get the second half, rather than go the full way and figure out that, oh, we kind of did something wrong and we probably shouldn't have done it that way. I would rather take a half measure, give us time to figure out the rest of the pieces, and then come back and finish it.
Yeah, you're obviously not an elected official running for office, right?
Yeah. You don't need to get elected. Yeah, similarly, all that plus one, it is, from a global harmonization perspective, what are the commonalities? Everybody put the brakes on, the brakes that didn't exist in the original cars, put those on. And then, what are the 2 or 3 or 4 or 5 principles that we all can agree to, and let's just start there and give each other a little bit of grace.
Yeah. That's good.
Harmonization with President Bush and President Obama, export control regulation. I think under President Bush and under President Obama, they were trying to harmonize the export control restrictions with our allies in Europe and across the globe because of shared values, and it was very successful.
Yeah.
Even Kevin Wolf with the export controls reform initiative under President Bush and President Obama.
Right.
We had a lot of that, and it was very effective in countering adversaries.
Mm-hmm. Yeah, there are models.
Yes, learning from that and
cooperation.
the concept of shared values and priority.
I know was critical, and as well as friends like Jeff Goodale, who was once associated with your firm.
All right.
Well, thank you all.
Thank
you so
you.
much for your time. Thank you, everyone.
Thank you. You were fabulous.
All right, I'm not going to stand long in the way between you and the door. I want to thank you again for coming to this conference. I want to thank this wonderful panel and for enduring my horrible question.
Sorry.
I do want to make one announcement because I think it's important to realize that when you come to an NYU event, you get the latest information. Today, the FTC is announcing an exploratory voice cloning challenge to encourage the development of multidisciplinary solutions from products to procedures aimed at protecting consumers from artificial intelligence-enabled voice cloning harms such as fraud and the broader misuse of biometric data and creative content. I won't say it's because we had this conference today that the FTC immediately issued this challenge. I would just note that sometimes things happen for a reason, and we're very proud to have been critically responsible. I mean, just happy for the coincidence, I guess is fitting. Once again, thank you very much for attending, and Godspeed with AI.